Hello and welcome dear friends. Today's topic is understanding of terms goods and sale under Sale of Goods Act. The main objectives of this topic are goods, types of goods, sale, essential of sale, contract of sale distinguished from other contracts, and effect of destruction. Originally the law relating to the sale of goods was spelled out in Chapter 7 of the Indian Contract Act 1872. This was subsequently repealed and the law is now codified in an enactment called Sale of Goods Act 1930. The Indian Act is more or less on the lines of English Sale of Goods Act 1893, except for a few changes which has been made to meet the requirements of the commerce in India. Prior to 22nd September 1963, the Act was titled the Indian Sale of Goods Act 1930. The word Indian was deleted by the Indian Sale of Goods Amendment Act 1963 passed on that date. The Sale of Goods Act 1930 is an act to define and amend the laws relating to the sale of goods. The act deals with the provision related to the contract of sale of goods, but it is not applicable on all the movable goods. Now the definition of the goods. Goods means every kind of movable property other than actionable claim and money. Section 2, subsection 7 defines goods as every kind of movable property other than actionable claim and money and includes the stock and share, growing crop, grass and things attached to or forming part of the land which are agreed to be served before sale or under the contract of sale. The definition of goods provided under the Act is comprehensive. It includes not only movable property but also immovable property which could be and is agreed to be severed before sale or under the contract of sale. For example, bamboos and the timber are goods. The incorporeal right like goodwill, copyright, trademark, patent can form the subject matter of sale. As regards water, gas, electricity, it is doubtful whether they are goods. It was held in MB Electrical Supply Company Limited versus State of Rajasthan. Actionable claim and money are not goods and cannot be bought and sold under this Act. Money means current money, that is recognized currency in circulation in the country, but not the old and rare coins which can be treated as goods. An actionable claim is what a person cannot make a present use of or enjoy, but what can be recovered by him by means of suit or an action. Thus, a debt due to a man from another is an actionable claim and cannot be sold as a goods, although it can be assigned under the provisions of the Transfer of Property Act 1882. Lottery tickets are goods and not actionable claims within the meaning of Section 2, subsection 7 of the Act. It was held in H. Anraj versus Government of Tamil Nadu. Now, types of goods. Goods may be existing, future and contingent. They are discussed as follows. Number first, existing goods. Existing goods means the goods which are either owned or possessed by the seller at the time of contract of sale. Section 6, subsection 1, these are goods which are in existence and are physically present in the seller's possession. The existing goods may be specific or generic, ascertained and unascertained. Number first, specific or generic good. Section 2, subsection 14, these are the goods identified and agreed upon at the time the contract is made. Second, ascertained goods. These are identified after the formation of the contract. Unascertained goods, these are the goods which are not specifically or agreed upon at the time of the contract of sale. Now second, future goods. Goods to be manufactured or produced or acquired by the seller after the making of the contract of sale. Third, contingent goods. A type of the future goods, acquisition of which depends upon the contingency which may or may not happen. A contingent falls in a class of the future goods. For example, A agrees to sell a certain TV set provided he is able to get it from its present owner. S, whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. There may be contract of sale between one part owner and the other. This is an agreement to sell contingent goods. In such a case, if the contingency does not happen for no fault of the seller, he will not be liable for damage. Now the definition of sale. According to section 4, a contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. There may be a contract of a sale between one part of owner and the other. A contract of sale may be absolute or conditional, where under a contract of sale the property in goods is transferred from seller to buyer, the contract is called sale. But where a transfer of goods is to take place at a future date, subject to some conditions thereafter to be fulfilled, the contract is called agreement to sell. An agreement to sell becomes a sale when the time elapses or conditions are fulfilled subject to which property in the goods is to be transferred. Thus, in contract of sale, there must be number first, transfer or agrees to transfer the property in goods, number second, to the buyer, number third, for the money consideration called the price. Now, essentials of sale. The definition of sale emphasizes these essential features. Number first, bilateral contract. According to Pothier, the contract of sale is consensual, bilateral and commutative. A sale is bilateral where a property in goods passes from one person to another. The seller and buyer must be two different persons because a person cannot buy his own goods. In a case before Gujarat High Court, in state of Gujarat versus Raman Lal and Company, a partnership firm was dissolved and surplus assets including some of the goods were divided among the partners. The sales tax officer sought to tax it. Court rejected the contention of the state. Bhagwati Justice said, I quote, that the partners were themselves the joint owners of the goods and could not be both the seller and the buyer, unquote. Moreover, no money consideration was promised or paid by any partner to the firm as consideration of goods allotted to him. In an agriculture market committee versus Shalimar Chemical Works, the Supreme Court laid down that a contract of sale, like any other contract, is a consensual act in as much as the parties are at a liberty to settle for themselves the term of their bargain. A sale is said to be a consensual because it is necessary that the parties should agree with their free consent. However, there are certain exceptions to the general rule that a man cannot buy his own goods. Where one person has under the law a right to sell another person's goods. For example, if law permits, a man may purchase his own goods sold under the execution or in distress. Similarly, a bankrupt may buy his own goods from his trustees. In a contract of sale, consent of the parties is essential. A forced purchase is an acquisition and not sale. Where property is compulsory acquired pursuant to the authority conferred by the statute, there is no sale of the property even though compensation is payable and its amount may be fixed by negotiation between the parties. In New Indian Sugar Mills versus Commissioner of Sales Tax, Supreme Court has held that where a sugar manufacturer is told to sell only at a stated price and to stated consumers, it is sale, but the buyer to whom this privilege is given are still free to buy or not. Similarly, in Coffee Board versus Commissioner Commercial Taxes, it was held that a delivery of a coffee to an agent under the government order not amount to compulsory acquisition. Elements of consensuality are nevertheless present in the transaction. The meaning of commutative contract is one in which things given or act done by one party is regarded as an exact equivalent to the money paid or act done by other and is distinguished from an aleatory contract such as a contract of insurance, in which an equivalent consists in the chance of gain or loss to the respective parties depending upon an uncertain event. No special formalities are required for a contract of sale. It may be written or oral or implied. Second, money consideration. The consideration must be money paid or promised. The agreement may be for cash or credit sale, but if an consideration other than money is given, it is not sale. However, money must be given as a price. It is not every transaction involving a transfer of property and a payment that constitutes sale. If goods are exchanged against goods, the transaction is barter and not covered under the Act. Where the goods are sold for a definite sum and the price is partly paid in terms of valued up goods and partly in cash, that is sale. For example, where corners are delivered on the terms that on the demand the price would be paid or equal quantity of corn would be retained, that is sale. No sale takes place without a price. Thus, if there is no valuable consideration to support a voluntary surrender of goods by a real owner to the another person, the transaction is gift and is not governed by Sale of Goods Act. Therefore, price, which is money consideration for a sale of goods, constitutes the essence of the contract of sale. Now, subject matter of contract of sale. The subject matter of contract of sale under the Sale of Goods Act is always goods. Now, transfer of property. The object of sale must be transfer of property in goods from one person to another. Now, the another essential condition is price. The price is an essential feature of the contract of sale which distinguishes it from other similar contract. Section 9 and 10 deals with the modes of fixing price. The price may be fixed at the time of contract by the parties themselves or may be left to be determined by the course of dealing between the parties or may be left to be fixed by some third party. Where the contract states that the price is to be fixed by the third party and he fails to do so, the contract is void. But if the buyer has already taken the benefit of the goods, he must pay a reasonable price for them. If the third party's failure to fix the price is due to the fault of one of the parties, then the party is liable for action for damage. Where nothing is said by the parties regarding the price, the buyer must pay a reasonable price and the market price would be a reasonable price. The reasonable price is a question of the fact depending on the circumstances of each case. In MP Lagu Udyog Nigam versus Gwalior Steel Sales, it was held that though the price is a part of the definition, its fixation can be done afterwards also. Sale must be conditional or absolute. Lastly, a contract of sale may be absolute or conditional. Absolute when there is no condition and conditional when the condition is attached to the contract. Now we discuss contract of sale distinguished from other contracts. It sometimes happens that a contract is defined in such form that it apparently appears to be contract of sale. But when its nature is analyzed, it is discovered that in reality it is not contract of sale but some other contract. The question whether a particular contract is a contract of sale or some other contract is a question of form. It depends on the real meaning and the nature of the contract whether it is to be construed as contract of sale or exchange or mere guarantee for the price or a bailment or a trust or contract of agency or contract of work and labor or gift or pledge or an award. Thus, a contract may be clothed in the form of the contract of sale or it may contain terms implying that it is a contract of sale. Yet, if on its true construction it appears to be some other kind of the contract, then effect will be given to it as such as provisions of the Act will not apply. Now, we will discuss the contract of sale from barter and exchange. Where the consideration for the transfer of the property in goods form one person to another consists of the delivery of another goods, the contract is not a contract of sale but is a contract of exchange or barter. But where a consideration is partly the goods and partly cash, it will be contract of sale. There must be a saleable property to be transferred in exchange of the price. Accordingly, money cannot be price of money. Where goods are transferred by one person to another without any price or other consideration being given in return, the transaction is called gift and it is not sale. Contract of sale distinguished from contract of work and labor. A contract of sale has to be distinguished from contract of skill and labor. In such contracts, one party engages himself to do some work for other and to supply his own material for the completion of the work for a pecuniary or other consideration to be paid by other party. The question that arises whether the finished article or a material supplied by a workman should be considered as purchased by the other party. There can be no contract of sale unless the contract contemplates the delivery of goods as not merely affixing the goods by workman to land or some other chattel. A contract of goods is distinguished from contract of work and the labor. The distinction is often fine and it is not clear, and the opinions have differed much as to the test for distinguishing between these two contracts. In Lee versus Graffin, a lady engaged a dentist to make two sets of fake teeth to be fitted into his mouth. Before the work could be completed, the lady died. In an action by the doctor to recover his charges, the contract was held to be one of the sale. The court emphasized that there should be seen the end of the transaction. If the result of the transaction is the passing of the article for a price, it is sale. Thus, where the main object is a transfer of the article, it is on sale, and where the main object of work undertaken by the payee of a price is not transfer of goods. The contract is one of work and labor. So, it is the substance of the contract that is to be taken into consideration. Now, sale distinguished from hire purchase agreements. A sale has to be distinguished from a contract of hire purchase because their legal incidents being different. In hire purchase agreements, goods are to be let certain terms at a rent payable by the monthly or other installments. The hirer has the option of purchasing them on the payment of the total amount of the installments, and it is stipulated that the hirer shall remain the bailee and shall not become the owner of the goods until he or she shall pay the whole amount agreed upon as a price. If the hirer in effect agrees to buy the goods through the price is to be paid by installments and not merely acquires the option to purchase them in future, the contract is contract of sale and not contract of hire. The essential feature of a contract of hire purchase is the option to give the prospective purchaser to terminate the contract and return the chattel. Wherever the option is absent, the contract is not of hire purchase. In Lee versus Butler, certain furniture was left to one Lloyd under the hire purchase agreement, whereby Lloyd agreed to pay the price in 2 installments. The owner has a power on default in payment or on removal of the furniture without his consent to take the possession of the goods, in which the case the previous sum paid should be approved to the rent only, but if the hirer duly paid all the installments and performed all the agreements, rent should cease and goods should then become the property of the hirer. Before all the installments were paid, Lloyd's wife sold and delivered the furniture to the defendant. In an action by the owner of the goods, it was held that the defendant had a goods titled as Lloyd has agreed to buy within the definition of the section 9 of the Sale of Goods Act. Now let us discuss the sale and agreement to sell, how it is distinguished. Section 4, subsection 3 brings out a clear distinction between 2 classes of contract, viz. Actual sale and agreement for sale. An agreement to sell is a contract pure and simple and not in property passes, whereas in a sale it is a contract plus convenience. In State of Bombay versus United Motors, the expression sale observed by the Supreme Court consists of number of ingredients which can be said to be essential in the sense that if any one of them is missing, there is no sale. Some of them are existence of goods, bargain of contract, payment or promise to pay, or passing of title. The points of distinction are: number first, a sale makes the buyer the owner of the goods. He can exercise all the proprietary rights in respect of them. He acquires a right against the goods, and its effect is that if the seller refuses to deliver the goods, the buyer may sue for recovery of the goods by specific performance. He can sue only for the damages for breach and not for recovery of goods. Second, in sale, the risk or loss if any of the goods is on the buyer, but in an agreement to sell, the seller remains the owner of the goods and therefore he runs all risk. In sale, if the buyer commits default, the seller may sue him for the price and is for specific enforcement of contract. In an agreement to sell, the seller's only remedy is to sue for damage for breach. Effect of destruction. The contract of sale of specific goods is void if at the time of contract the goods have, without the knowledge of the seller, already perished or as damaged as no longer to answer the description. The rule is subject to the following condition. Number first, the contract must be for the sale of specific goods. Second, they may have perished before the contract is made and without the knowledge of the seller. Goods perish after sale. An agreement to sell specific goods becomes void if subsequently the contract without the fault of the seller or the buyer has perished or becomes so damaged as no longer to answer the description of the agreement provided. This happened before the risk has passed to the buyer. An agreement to sell a horse after a few specified days becomes void if the horse dies in the meantime. With this we conclude this topic. Hope you have understood it well. Thank you.